all sides are duly represented. The learned counsel for respondent number 1 submits that the respondent number 1 has superannuated on when
31/3/2021 also.
31/3/2021.
For 9/3/2022, Lordship, I have intimated the
I've seen that.
Lordship.
Which is also recorded in the order dated 9/3/2022. Mr. Sharma, this P. Jidung is not the
Yes.
director now.
Yes.
He is the director.
No, he's no director. Director is Mamata Hossain.
He superintendent or he is in service. P. Jidung.
A retired minor.
Mr. Mr. U. Sharma, Rana, standing person for the Elementary Education Department or Secondary Education Department, submits that the respondent number 2, P. Jidung, has also superannuated.
No, my colleague informed me he is
Transferred, okay. Transferred, and another incumbent holding office at present. The counsel for the petitioner shall take note of the same. Next paragraph. The learned standing also for the Secondary Education Department has produced a set of instructions along with letter dated 13/12/2022. So with the stand of the concerned official be brought on record by filing an affidavit in the matter. The instructions produced are returned. List again on
And my lord, Mamata Hossain is not a party here, my lord.
it's okay, but since you are producing it,
So let the Mamata Hossain be party. Same thing.
so once you are producing it, I am asking you to file it on affidavit. But 5th is we are otherwise busy. This is matter on 10/4/2023. Instructions I am returning.
Item 2, my lord, I will take the steps. Of
Item 2.
respondent number 6. I will take first step.
Mr. DCC Fugal and counsel for the petitioner submits that he will take first steps for service of notice on respondent number 6 by registered post with AD.
Probably respondent number 6. My lord.
On respondent number 6. So prayer is allowed. Still be taken within 3 working days. Notice is made returnable on so and so. You have fixed date. List accordingly. Just before that, you write. It is noted that It is, it is noted from the order sheet, from the note sheet. That note sheet dated 17/12/2022. That notice was issued on respond messages by registered post with AD. So the registry shall put up a note as regards service. In the meanwhile. List on Spencer.
Then put it on. Then I go to then put it.
For, no, no. 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 Right. List on 3/5/2023. No, not 3/5. It'll take 2 or 3 days to process it. We'll make it 11th May, 12th May. Okay.
Problem. Number 4 for learning.
Sir, in this method, R Mozumdar will appear, my lord. Item number 4. I do. Or
May I
lost
please-
4.
may I please, your lordship? Lordship, here on last occasion, my lord, when there was the date fixed for hearing argument in the lower court, my lord, on that date, the learned court as was on transfer. He has fixed another date for 11/4/2023 for argument, my lord. My lord.
No, you see,
and-
for the trial court, I am not keeping this matter pending from 2015. 2015 today will be 8 years. Correct.
My lord.
You make a submission on it, we'll examine and then,
My lord, one more, thing, my lord, may kindly take this matter on any other date, my lord, on Tuesday.
no, Tuesday I have,
Any date, my lord. My lord, I was on leave since last Friday as my daughter was admitted on Friday on
Okay.
Pratiksha, my lord. I was on leave, my lord. Today I came for this matter only, my lord. Any date, my lord, on next week, my lord. On as per my lord's convenience. Okay.
no, it has to go after you now. Outside the duly represented, Ms. S.G. Barwar and counsel for the petitioner submits that the proceedings of GR case number 326 of 2018 has been referred to
11/4/2023
11/4/2023
for argument.
for argument. So she also submits that her daughter is hospitalized and therefore she pays for an adjournment. So, on the ground of illness assigned, all the matter stands adjourned today. Next paragraph, the issue in this case revolves around projection that the criminal proceeding as well as the departmental proceedings are on same facts. Next paragraph, having noted that this matter is pending for last 8 years. Now the court proposes to hear the matter, notwithstanding whether the criminal proceedings are disposed of or not. Next paragraph, accordingly, let this matter be listed for hearing on
25/4.
25/4.
Obliged, my lord. Hello.
5 to 8.
That be your lordship, madam. Just for a time, remember, as soon as coming.
Okay.
I have to wait.
Number 9. 9, 9 and 10.
Yes, the affidavit is filed.
Lordship, I'm appearing for the elementary education. Lordship, accordingly, according to the last orders, Lordship, we were able to file to e-filing. It's on record, Lordship, the affidavit which we were supposed to file. Affidavit, my lord, in opposition starts from page 594. Has been filed in, my lord, 5250 of 17. That bit.
That is. Which page? Page number?
Lordship, 524 of the, it starts from there, my lord, 520. Yeah, my lord, basically, my lord, the main this thing starts from paragraph 3. 2 writ petitions are filed, that is 17, 18, that is these 2 matters. Then, my lord, all these matters were pertaining to Kachar, my lord. Anomalies in the gradation list were found. And then, my lord, what happened was, my lord, similarly, my lord, in 2019, similar district cases had been
No,
filed.
this 522, the affidavit, you are saying that it is in 522 page.
525.
It is 5250.
Five-
That is a affidavit of Rajat Kanti Chakravarti.
No, 594. And it's quite a voluminous affidavit. It has been filed on, my lord,
You give a requisition slip, it is not here. 594 you are
in
saying.
the online thing, my lord, it's shown as I filed it long back, my lord.
It's okay. You have a copy with you?
I have a copy. Ma'am. Have an extra.
ये तो e-filing कोई सा है कॉपी है फिर भी बता दें page 594 e-filing कोई सा है not for you 5250 please let us one more two three in opposition 15323
It was on 23, I think they have filed it, not on 15.
no it is on e-filing is on 15th
15, it was not accepted.
okay
Subsequent-
whatever but this okay that's okay it was filed on 23
23, physical
Yes, sir.
copy, and
Physical copy.
on 23, filing was accepted.
okay
My lord, paragraph 3, my lord, what happened was, my lordship, we have stated that on in the year 2017 and 18, WPC 5250 of 17 and 5219 are filed. There are these 2 current writ petitions pertaining to anomalies in the gradation list or in the district of Kachar. wherein, my lord, it was alleged, my lord, procedure was not followed. Subsequent to that, my lord, if your lordship comes to if your lordship comes to paragraph 4, there, my lord, separate writ petitions were filed bearing number 2567 of 19, involving the same issue regarding the gradation list of the Kachar district as that of 5250 of 17 and 5219 of 18. There, my lord, what happened? Order dated 12/4/19, my lord, directed the respondent authorities to produce original records, more particularly the relevant file bearing number EHA B24 of 16, for proper adjudication of the case, my lord. Accordingly, my lord, the department sent the original records, my lord, to the senior standing counsel office, my lord, which was received on 3/5/19, my lord. This, my lord, it is indicated in the logbook, my lord. We have annexed the logbook mark also, my lord. Is that
Where is that?
that is, my lord. My lord, page 620. Accepted 620. 620, my lord. There, my lord, it's given 3/5/19. To whom address senior standing counsel contains EHA B24 2016 file. It has been received by our office, my lord. Accordingly, my lord, after that, my lord, that the Learned Standing Council, after receiving the concerned original file, my lord, bearing number EHA B2416, produced the same before the honorable court on 4/5/19, my lord, in connection with WPC 2569 of 19, which is already indicated in the order dated 4/5/19, passed in WPC number 2569/19, my lord. Lordship
you-
comes to page
but-
616, my lord.
No, just I'm trying to understand. You see, let us assume what is stated here is correct. Correct. Now, if it is lost at the end of the council, you'll have to lodge an FIR. Correct. The second thing is that after that, you'll have to move the authorities and have the files reconstructed. Because it can't be that the matter is kept pending here and you don't do anything, because once it has come to light that the records are missing, you'll have to reconstruct it.
And my lord, we gave this thing to the registry also to look, my lord. In the disposal, it's not there. So it might that my lord, Mr. Majumdar also, when he's supposed to come, my lord, he's on legs, my lord. Might be on the other, might be there also, my lord. You have to check it out, my lord. On the disposal side, it's not there, my lord. So we'll have to check it.
I understand. You can only what you can do is that you can only request the register administration to look into it.
the thing. Yeah.
But if it is not available, you'll have to lodge an FIR that it is missing.
My lord, can then, my lord, before coming to that, my lord, can it be taken after some time? I'll inform Mr. Majumdar also. He'll also be there, because that part, my lord, he'll have to say it.
Because when the adjudication is started, we'll have to bring it to a logical conclusion whether the records are there or not.
My lord, my lord. And my lord, for the proper adjudication, the records will be required, because even the department could make the parawise because the records were produced here, my lord. So they are unable to, my lord.
At the time of disposal of this case, lordship, it was not pointed out to the honorable court also that records were called for. That 5269 at the time of disposal. Either of the parties. These two petitioner.
Receiving was there, my
respondent
lord. Receiving of the records by the court was there, but discharging of the records by the court was not.
No, it is noted in the order that records are produced.
Yes, at the time of disposal of the case. This case has been disposed. It's 5269. At that point of time, it was not also brought record.
No, you see, it's a regular feature. They produce the records. I may note it, may not note it in the order. It is happening in usual course.
And
My lord, take it out after some time, my lord. I'll in the meantime.
Because it,
Gradation list, etc.
it happens every day.
My lord.
Even yesterday, I have received a record.
Yes, yes, ma'am.
I have kept it in the custody of the court master. But today when after signature, when the files are scrutinized, then that entry that it has been kept with the court master is not there. So mistakes do happen. Because once the order sheet is there, it's available. Then the only thing we can do is that we'll have to, once an FIR is filed, as per their procedure, they have to reconstruct.
And documents we have submitted, most of the documents are obtained by RTI application, the impugned gradation list also. From
No,
the
they will have their
district
own
office.
system because they have their BEOs, DEOs,
Yes,
the concerned officers in the district level, they can always reconstruct
constructed.
My lord, we'll take care after some time.
after something, okay.
Deeply updated.
After some time.
Sorry, my lord.
Yes, no, it's okay.
There's a 4-5 matters, total my lord matters. Mr. Nair is also appearing in this case, my lord. So today he also
Yes,
told me
yes.
that he's not feeling well, my lord.
He's given you a walkover today.
My lord. Two things, my lord. One thing, if I start my argument today, and the second thing is, my lord, since Mr. Nair is also there, can it be taken up after that, just after this 15th of this vacation, my lord, first week of after this celebration? Can it be possible that when one stroke lordship can finish this?
How much time you propose to take?
My lord, to be very honest, lordship knows when the case is too good, it takes 2 minutes. When it takes a little mediocre, it takes little more. When case is little, then it takes more, my lord. I think we'll take little more time, that's why.
No, but then with that statement, there's other things which are attached. It is that when you have a, just like you said, when it's a good case, it takes 2 minutes. But if it's a really bad case, then you'll also have to strengthen yourself and bang the table.
Yes, bang the table and then it takes time
So
little.
you're taking adjournment to gather strength.
No, then
bang the
that is
table.
not, we don't subscribe. That banging tables might be a little away from all this, my lord. That is not our cup of tea. So, my lord, take it after this, my lord.
That's 2016 matters. I'm
16, that's
finding it
right.
very difficult to adjourn these matters.
My lord. One more chance, maybe even once as the last chance. Because I also talked to him in the morning, he said he's not feeling well. Issue is, my lord, the issue is the Kentish,
It is only after authorities have realized why Great Law has become ill. They have started electricity, in the literacy report, they have started prepaid meters.
in fact, my lord, I'm also trying to find out. We are out, my lord, from the decisions of anything there in this case also, my lord. So I think it will also help me during these days if it's taken up. Issue is about, my lord, net and slat, whether the candidates that got net slat, actually they are appointed during the bencher stage in 2001. Their service was confirmed, they got the increment, everything. Lastly, by the impugn order, their increment has been status order passed regarding the increment, my lord. Then they came before the court, my lord.
No,
But that's
but
the issue.
now you see under the under the present guidelines, this net slat is a mandatory requirement. Even the Supreme Court has held that it has a mandatory application.
Yes, yes, like.
So this, in fact, I was finding nothing in this repetition to.
They say from the body language, lordship can understand, my lord. That's why I don't want prayer, my lord. At least give us after the vacation, let us see if something we can, my lord. To be very honest. And I told my client also directly, my lord.
Also, is duly represented on the prayer made by Mr. I'm not senior counsel for the petitioner. Matter was adjourned today. This one, whose date? After the
Second,
petition. Second to 5/2023.
I am for only item number 5.
Item 5.
Yeah, rest, I think Mr. Nair.
Yes, in, isn't it 5? Rest of the items you are there. Prayer maintenance, so you can hire senior counsel.
In my all cases, I have appeal matter Dima Hassan.
अच्छा, Mr. A. Khanikar, standing counsel for Dima Hassan, and Mr. D. Upamanya, then it's standing counsel for the
Higher education.
Higher Education Department. Just record their presence.
Obliged.
Obliged.
item number 11.
Yes.
And this is that case where there were multiple FIR
Yes.
according to the petitioner in this. Lordship may dispose, the petitioner is also not interested. If he makes out a case that in all the FIR allegations are same and therefore it should be quashed as they have made the prayer in the writ petition, my lord, then it could have been examined by your lordship. Since the petitioner himself is not there, my submission will be let it be clubbed and let it be taken up as by one particular police station. That will be possibly in the fitness of things, man.
Citizen call for the petitioner. Mr. D. Mazumdar, Additional Advocate General, assisted by Ms. D.D. Rahman, Additional Senior Government Advocate, has submitted that the petitioner had been unrepresented when the matter was listed on 23/3/2023. And even today, he is absent on call.
Second.
Accordingly, it is submitted that the petitioner may not be interested to pursue this matter. Should I return this to you because
My lord. Oh, yes. Oh. This contains the writ petition itself. I am searching for it.
I can understand.
Let
You would be handicapped because of this.
My lord.
This
let the petition be disposed of with the direction that all will be taken up by one.
But I have recorded your statement that you are paying for dismissal.
My
That I
lord,
have
yes,
recorded.
yes.
Next one. By filing this petition under Article 226 of the 227 read with Section 482 CRPC. The petitioner has prayed for quashing of the FIRs registered against him in BTAD areas. So the FIRs against him are as follows. Number one, FIR number 504 of 2020, registered at Kokrajhar PS under section 153 oblique 153 capital A oblique 182 oblique 506 IPC. FIR number 223 oblique 2020, registered at Dhaligaon PS under section 124 capital A 295A IPC. Number three, FIR number 114 oblique 2020, registered at Fakiragam PS under section 153 capital A 504 oblique 505 IPC, read with section 67 of the IT Act.
চার্জশিট হয়ে গেছে কিন্তু প্রবলেম স্টে আছে ঠিক আছে
But Mr. Mazumdar,
My lord,
there's something which I must ask you.
my lord,
You see, this FIR,
my lord.
if I understood it correctly, page 13 and 14 is the text of the FIR, right?
13.
Of the petition.
Yes. My lord.
Now,
There was no station. 13, 14, my lord.
Page 15 is the type copy of same variety. Yes.
no, but here the signature is, that's what I'm asking you, 9/9/2020,
My lord.
page 14.
My-
Who's the, who has lost this FIR?
This was by the petitioner himself.
Kokrajhar PS case number 503. Oh, acha, he has filed a cross case.
My one more aspect I have to point out to you.
Acha, next, the case presented by the petitioner is that on 3/9/2020 and 6/9/2020, he was interviewed by some local digital media, wherein he had made a statement to the following effect. Inverted commas, ... For the sake of electoral politics, the United People's apostrophes party, right, people, then apostrophe, then S. party, comma, liberal, within bracket, UPPL, bracket closed, in today's date is doing divisive politics and taking support of certain elements who, irrespective of their caste, community, and religion, either follow or believe the ideology of Muhammad Ali Jinnah or Mir Jafar, JAFAR, invert comma closed. First off, thereafter on 7/9/2020, Muhammad Moinul Haq, MOINUL of HOQE, belonging to UPPL party, had made a statement before the media and provoked the Muslim community to file multiple cases with regard to a aforesaid statement of the petitioner. Accordingly, the petitioner claims that he has lodged an FIR against Moinul Haq before the Kokrajhar police station, which was registered as Kokrajhar PS case number 503 of 2020 under section 153, 182, 506 IPC. First off, it is projected that as a counterblast, the hearing before referred 3 FIRs were lodged against the petitioner. First off, on a perusal of the set 3 FIRs, it appears that the text of all the 3 FIRs are similar to a great extent. First off, next, Mr. Mazumdar, even when you are considering, we can't do it because the informants are not parties here in the writ petition.
Yes.
I'll not be able to do it. Next, madam. Be that as it may, the court finds that the informants who had lodged the FIR in Kokrajhar PS case number 504 of 2020, Dhaligaon PS case number 223 of 2020, and Phagiragaon PS case number 114 of 2020 are not added as party respondents in this writ petition. Next one. Had this writ petition been, had the prayer made in this writ petition been made only under section 482 CRPC, it was quite possible that the state could have been heard in the matter and appropriate orders for clubbing the FIRs could have been made. So however, this is registered as a repetition, this application is registered as a repetition. And therefore, before the court proceeds to adjudicate the matter, the parties, the persons who have lost the FIR would have to be heard. By putting them on notice, Gustav. However, those private respondents, the parties who have lost the FIR are not parties. The court finds that the relief is paid for cannot be granted in the absence of such proper and necessary parties. Next one. Be that as it may, as the petitioner is absent on call, instead of disposing of the case on merit, the court proposes to dismiss this matter for non-prosecution.
And the interim order passed earlier may also.
Interim order passed on which date?
This was passed on my note. 29/9, my lord. 29/9/2020.
29/9/2020. Just before that, you also write. It may be noted, just before dismissal before. It may be noted that this court by order dated 29/7/2022 had mentioned that the had required that the learned counsel for the petitioner shall satisfy the court on the maintainment of this petition Article 226 and 227 of the Constitution of India for quashing of the FIR registered against the petitioner in BTAD region. However, the issue of maintainability was not raised in respect of the provision of section 482 CRPC. So it is also observed that as for order dated 20/12/2022, the court had recorded the submission made by the learned Additional Advocate General that as the prayer is to quash an FIR, and therefore it is required to be examined as to whether in a writ petition, the concerned police station and the concerned IO is a proper or necessary party. And accordingly, the London counsel for the petitioner had prayed for and was granted time to obtain instructions and to take appropriate steps. And thereafter, the matter was and thereafter, the London counsel for the petitioner was absent on call on 14/3/2023. And by order dated 29/7/2022, this court had reiterated the requirement of the learned counsel for the petitioner to satisfy the court on the maintainability of the petition. Thereafter, the matter was listed on 23/3/2023, and the petitioner was absent on call. This was for non-prosecution. Everyone court is of the constitution, the witness is not interested to pursue this matter. After the issue of integrity was raised, the matter is dismissed for non-prosecution. We have the order passed today. I disposed of.
Part two hearing list.
Is not happy with the order. I would have been happy to accept your initial submission.
My circumstances is such.
Because you see, if I do it, then it will be a wrong precedent.
Okay.
I was thinking that line. Last night also I told you,
Yes,
I was thinking that line, but then I realized that if I pass an order, it would be a bad precedent. Now, matter is over. I'm just asking you, is it, was it appropriate not to entertain because of that non-joinder?
Yes, ma'am, it's a read petition. And madam, there are judgments to show, madam, one judgment of the High Court. Then while considering the question of quashing of an affair, because in the meantime some time has elapsed, the IO and the officer of the police station also should be given opportunity to place materials on the basis of which they want to
Please give me that
establish.
citation. It will be. But this is something I'm not aware.
Not really in the context of parties made in the read petition. This is my lord, 2016. Your lordship will get it in Supreme today. 2016. Two crimes within bracket High Court, HC, page 119. Dr. Brahmanand versus State of Karnataka. Para 11, this has been mentioned by.
Dr. Brahmanand is a case I have read, but I missed this.
Maybe.
Ah.
Deals with quashing of affair only.
Huh.
Public.
Part two hearing list, item number 50.
There's no. I don't get to part two. There is no representation from the petitioner. Mr. U. Sharma, standing counsel for the higher education, for higher education, who will be there?
One.
Higher education?
Higher.
No, who's there, council?
Only it is secondary education.
Oh, secondary education, yes, yes. This is secondary education matter, okay.
50.
Okay, second, you'll be appealing for secondary?
Yes, yes.
Okay, so Mr. U Sharma, then is standing also for the secondary education department. Is present. Next, by filing this writ petition in Article 226 of the Constitution of India. The petitioners have prayed for setting aside the impugned communication dated 6/11/2015 . Six ten 2015. Issued by the Director of Secondary Education, Assam. Directing the respective inspector of schools to start the process of selection to the post of postgraduate teacher in different provincialized higher secondary schools to TET qualified candidates. And for directing the respondent authorities to allow the petitioners to participate in the ongoing selection process by relaxing the BT of the B.Ed qualification beyond 1/1/2015. So the grievance of the petitioners is that although the petitioner had qualified in the TET examination in June 2014 and were entitled to the benefit of relaxation from BT B.Ed qualification, the selection process was not undertaken prior to 1/1/2015, in spite of availability of vacant posts. And it is, and the petitioners claim that by reduction the requirement of having BT B.Ed qualification beyond 1/1/2015, the petitioners be allowed to participate in the ongoing selection process. The learned standing counsel for the Higher Education Department,
Second section.
Secondary Education Department has referred to the order dated 23/3/2023, wherein the submissions are accorded to the effect that there was an exemption by Ministry of Human Resource Development to exempt recruitment of non-BT dash B.Ed qualified teachers, which was valid up to 1/1/2015. And as the present norms has come into force requiring only TET qualified teachers to be appointed, comma, the authorities would have no power to relax the requirement of BT B.Ed beyond 1/1/2014. Next one. This matter was previously called on 23/3/2023. The matter was adjourned as the petitioners were not represented. So the matter is taken up in the second call today, and today also the petitioners remain unrepresented. Accordingly, the court is of the view that the petitions are not interested to pursue this writ petition. Accordingly, this writ petition stands dismissed from non-prosecution. The interim order passed on 12/11/2015. Otherwise, extended from time to time, stands vacated. Mr. Sharma, I'll wait till 2 o'clock.
Yes, ma'am.
We'll be signed only thereafter. If they come, we'll take up the matter of merit.
Yes, yes.
51.
My pleasure, Lordship.
Yes,
Lordship, the counsel for the petitioner, Mr. M. Ahmed, is not well today. Matter may be taken on another day.
taken up in the next, on the claim made by and counsel for the petitioner. Matter will be called, taken up in the next call.
52 and 3.
Yes, you are appealing the matter.
My lord, I have done brief, my lord. Kindly pass order, my lord. I'll take the brief, my lord. This is the office, my lord.
Second. They're asking for the revised UGC scale because they have qualified, obtained the MPhil qualification prior to the cutoff date. Anybody is ready with the matter, Mr. Saiwala? Okay, he was there.
Yes. Yeah, in this case, one of the, I learned senior counsel, Mr. Yugan is supposed to be arguing, but he is not in a position to argue the matter.
Okay,
Any other day.
you suggest a date, we'll take it up then, Mr.
Yes, yes,
Saiwala will, you
Yes.
suggest a date when? This is valid.
I have no choice. I have no choice, madam. Any date.
You have a calendar, just look at the date. There's a calendar in front of you. Have a date.
After you, my lord, it may be on 27th.
Yes.
This is matter we called on the prayer made by the Learned Counsel to the petitioner, matter stands adjourned today. Mr. G. N. Saiwala, Learned Senior Counsel for the private respondent is present. List on 27/4/2020.
Master President.
56 also connected. 66 also connected. Item 56 connected.
67 will be taken up. 67.
Who's for the other side? They are present.
Higher education, my lord. Sunita Devi.
No, but there are private respondents, you have to call them.
Yes. Then at 2 PM, I'll inform them, my lord.
Ah, yes. So 80 Sarkar is there. Correspond number 8. RP Kakoti for respond number 7.
Yes, my lord, I'll
Just
inform.
inform them. I'm picking up the matter for hearing.
May it please your lordship. Your lordship, in item number 66, my senior Mr. K. Chaudhary will appear, your lordship. But let the matter may not be taken up today, your lordship. Let the matter be taken on some other day.
66.
Yes, your lordship.
Okay, let me reach there and pass orders.
Lordship.
We'll make a note. I'll pass orders when I reach there. Mr. Kumar,
Lordship.
in this 52-53,
Lordship.
they say that because of their MPhil degree which they have acquired prior to the cutoff date,
Lordship.
they will be required to be given a UGC pay scale.
Lordship.
Lordship and MPhil, Lordship, the net slate MPhil is not exempted by the UGC at any point of time, Lordship. It is mandatory, Lordship, since Lordship 2000, since 1998, Lordship, 1991 itself net is mandatory. But 1998 UGC formally and it is mandatory, Lordship.
But
And
here
it
it is, here it is projected.
Lordship,
There was an exemption.
Lordship. That exemption, Lordship, we cannot, Lordship. And it's a conditional appointment, Lordship, page 20, Lordship. Page 19, Lordship, is a conditional appointment, page 19, Lordship. That particular appointment letter was issued on 22/8/2002, Lordship. Where page 19, Lordship, type copy, Lordship.
Okay,
Page 19, Lordship.
but you granted them, this order was,
Lordship,
this order states that the appointment was subject to clearing net slet.
next slide, Lordship,
Yes,
next slide, Lordship. Tulika Das is page, Lordship, like 16, Lordship. Page 16, petitioner number 1 is page 16, Lordship.
yes,
With a conditional appointment, Lordship, they have to fulfill that condition, Lordship.
yes.
Lordship. And even, Lordship, similar line of matters came up before the Honorable Court number 17, Lordship, day before yesterday. That was also, Lordship, order, Honorable Court observed that, Lordship, they have to acquire net slate as part of their appointment, Lordship. The order was not uploaded, Lordship. If Lordship fix the matter next week, we can place that particular order also. Exactly same case, Lordship.
You come to page 26 and 27.
Lordship,
This is from the UGC. 14/6/2006, page 26,
Lordship, page 26.
page 26.
Lordship,
It's a notification of 14/6/2006
Lordship,
by the
Lordship.
UGC.
Lordship,
Last line you see, they come into force with immediate
Lordship.
effect. That means 14/6 it comes into effect.
Lordship,
Next page, please turn.
Lordship,
The in the UGC so and so,
Lordship,
wherever following para occurs,
Lordship,
should be substituted with the following.
Lordship,
Then
Lordship,
last para is net
Net,
plate
sir.
so and so. Our
Lordship,
candidate having PhD and concerned subject
Lordship,
exempt from net for PG level
Lordship,
and undergraduate level teaching. The
Lordship,
candidate having MPhil degree in the concerned subject are exempt from net for
Lordship,
undergraduate level teaching only.
Lordship,
So therefore, this is what they are showing.
Lordship, that was already dealt by the Honorable Supreme Court also, Lordship. And Honorable, as per the direction of the Lordship, the central government, Lordship, that they are bound to the Lordship direction given by the central government.
Yes.
Central government says that, Lordship, the UGC's guidelines cannot override the direction of the Honorable Apex Court says that UGC's guideline cannot override the direction given by the central government under section 20 of the UGC Act, Lordship. Paragraph 12 of the P. Susila's case, it is clarified, Lordship. So, Lordship, there cannot be any exemption in the net and slate, Lordship.
Okay. P. Sushila, you presented on the last date. No, I have it. Last time you
Lordship.
gave us.
Back to Anasandi, P. Sushila, Lordship. And Lordship, moreover, their appointment was done in Lordship 2002, Lordship. 2002, at that relevant point of time, Lordship, net and slate is the mandatory requirement, Lordship. And they now cannot claim the subsequent guidelines or Lordship, other things, Lordship.
Mr. Gogoi,
Lordship,
this Susila spelling is different.
Lordship,
SU?
SUSEEL, Lordship.
SUS.
Double EL, Lordship. SUSEEL, P. Susila, Lordship. P. Susila, Lordship. 2015 8 SCC 1 to 9, Lordship.
Paragraph.
Paragraph 12 says lordship, it starts from lordship, paragraph 7, 8 lordship. 7, 8 lordship, where the UGC has lordship, grant relaxations to the persons lordship who have obtained lordship, MPhil degrees lordship, paragraph 8 lordship. Paragraph 8. And lordship, in respect of paragraph 27, where lordship has indicated that lordship MPhil is lordship exempted, those persons who have submitted registered before lordship 31 December 1993 lordship. And lordship, particular page 28 lordship, whereby government
Just a moment.
lordship,
This, the petitioner number 1,
lordship,
he was in Tinsukia College.
lordship.
Tinsukia College is a postgraduate college,
No lordship, it's a
undergraduate college.
undergraduate college lordship.
Okay.
Up to lordship, degree level is there lordship.
Okay. Will degree.
And my lord, regarding page 28 of the writ petition lordship, that particular exemption notification issued by the government of Assam lordship on the basis of lordship 473rd or 472 lordship, the UGC's resolution lordship, that was dealt by the P. Susila's case honorable apex court lordship, whereby UGC has
Okay, I get it.
lordship, whereby UGC has decided to exempt the MPhil. That was negated by the honorable apex court on the basis of the letter issued by the central government lordship. Even my lord, in 1991 itself lordship, when the UGC's regulations came into force lordship, then net is the mandatory requirement lordship. In that regard, one case came up before the honorable apex court lordship. It was decided on 1996 lordship. That also honorable apex. Citation is lordship 1996. Then is
Just a moment.
lordships.
Just a moment.
Lordship. Thank you. Paragraph 21 dot clause.
Yes, what is the case you are referring to?
Lordship, in that particular case regarding Lordship, the cutoff date, which was 31st December 1993, Lordship, exemption part, that was dealt by the Honorable Apex Court. Honorable Apex Court says that that was done because Lordship, prior to 1991, Lordship, there is no provisions for Lordship, the net and slate mandatory, there is no any regulation. So to save the persons who have obtained the Lordship MPhil and PhD prior to 1991, Lordship, they have, Honorable Apex Court says that their particular cutoff date 31st December 1991 is Lordship not to be disturbed, Lordship. That was
What is the citation?
that was Lordship in 1996 10 SCC 536, Lordship. Just I am indicating, Lordship, what Honorable Apex Court dealt with, Lordship. 1996 10 SCC 536, Lordship.
You are there in the matter?
Lordship, in item number 68, Lordship, I'm led by Mr. R.K. Kaute. Lordship is not in town, Lordship.
Just wait for some time. The fire has gone to search for you.
There was the issue was regarding Lordship appearing of the Bihar eligibility test, Lordship. That particular issue is there. One notification was issued by the state of Bihar, Lordship. They have said that, Lordship, the persons who have acquired MPhil and PhD, Lordship, prior to November 2022, Lordship, they have indicated that, Lordship, up to 31st December 1993, they are not required to, Lordship, net and slate, Lordship. That part was there discussed on Honorable Apex Court, Lordship. That particular cutoff date, Lordship. And UGC, Lordship, no point of time after that, Lordship, exempted the MPhil holders, Lordship. And Lordship, moreover, their appointment is a conditional appointment, Lordship, and it was covered by the Honorable Apex Court, Lordship. The law laid down by the Honorable Apex Court, Lordship, M. Palanaswamy's case will be covered, Lordship, where Honorable Apex Court says that, Lordship, conditional appointment, Lordship, they have to bound to follow the the conditions which are stipulated in the appointment letter, Lordship. Paragraph 36 of the Palanaswamy's case, Lord. I will give the citation. Lordships, 2009 6 SCC 482, Lordship. 2009 6 SCC 428, Lordship. MP Palanaswamy, Lordship. Here, my lord, I am relying paragraph 30, Lordship. Paragraph 30, Lordship.
Does the paragraph start?
Lordship,
How does this paragraph start? Para 30,
paragraph 30, Lordship.
how does it start?
Lordship, it cannot be forgotten that regarding Lordship, Palanasamis, Lordship,
Yes.
Lordship. My lord, it cannot be forgotten that this regulation was all along accepted by the present applicants. Once they chose to accept the regulation, which was conditional, then it would have to be borne in mind that they have accepted the conditions also, Lordship.
Just pass it on. I'm not getting it.
Lordship, Lordship.
Just pass it.
Here also, Lordship, petitioner was appointed in 2002 itself. All along, they have accepted the conditions. Only they have filed the affidavit in writ petition 2015, Lordship. In Palanasami's case, Lordship, the petitioner has challenged the particular condition order after
Just
6 years, Lordship.
just
Another conditional
Just-
appointment judgment is also there, Lordship. Yes. Okay. Even Lordship, paragraph.
Okay. Yes,
Lordship, in another judgment, Lordship, 2015-14 SCC 382, Lordship. 382, Lordship.
2000,
2015-14 SCC 382, Lordship.
yes,
Surendra Kumar, Lordship, where paragraph 14 says that if Lordship permit, I can read it.
yes,
That's paragraph 14, Lordship. Here it says that Lordship, having accepted the appointment orders dated 6/8/2010 and also joined the post, the appellant cannot turn round and claim regulation with retrospective effect. There was also condition there, Lordship. I will pass it, Lordship. Even in another WA, Lordship, 79 of 2017, Lordship, Gauri Shankar Das versus State of Assam, Lordship. Here the Honorable, our High Court Division Bench also says that, Lordship. If Lordship permit, I can read and pass over.
yes, yes.
Lordship. The question for determination is whether the appellant can be allowed to challenge the conditions set down in notification dated so and so, when at the same time they have derived benefit out of it. It is not in dispute that the appellants came to be absorbed in the irrigation department on the basis of the said notification, which is the genesis of the order dated so and so. While taking benefit of the said notification, the appellant expressed no disagreement with any of the conditions stipulated therein. In fact, the appellant accepted the same and yielded it that to the terms and conditions set down therein. It is also seen that the early order dated so and so, no direction had been issued towards the absorbing the petitioner retrospectively as per the notification dated so and so. By means and related writ petitions, the appellants have tried to take undue advantage beyond the parameters set down by the notification dated so and so. We cannot subscribe to the pair of the contention set forth by the appellants, as the same is fanciful and without the legal basis. Here also, Lordship, Honorable, our division bench says that, Lordship, Once you have accepted the conditions stipulated in the notification, lordship, and join the service, you cannot turn back, lordship. Lordship. Okay, serial number 2 and 3, lordship. এখন কপি আনলো না কপি আসলে কপি
Okay.
And my lord, admittedly, petitioners have obtained MPhil degree, lordship. Page 31 onwards, they have given their certificate in 2010, lordship. 2010, both the petitioners 2010, lordship. One is from the Global University, Nagaland, lordship. Another is from Madurai Campus University. It will be lordship covered by the P. Sushila judgment, lordship. Paragraph 12, lordship. It will be covered by. Even they have also one point in the petition they have raised, lordship, regarding lordship negative equality, lordship. Some person said, lordship, in that regard, my lord, I have relied one judgment of the Honorable Apex Court latest judgment. I
have that you have given it to me.
Lordship, paragraph 24, lordship. My lord, may keep it. We have the copies, my lord. Complete position. Paragraph 24. No. Paragraph 24 onwards, lordship. In earlier paragraph, honorable court decides the law laid down by the honorable apex court in this point, lordship. In paragraph 24, lordship, is a concluding remark given by the honorable apex court, lordship. Para 24, lordship. In the last page, lordship, last page, para 24, lordship.
Yes, this have relied on.
Lordship,
last
lordship.
result.
Already lordship that judgment relied on. Oblige, lordship.
I'm giving it back to you.
Lordship, lordship.
Come back. So take a break and come back.
Lordship, lordship.
We can conduct the matter subject to your lordship. We have not bought the file today. If your lordship grants us access to the second file, I can conduct the matter.
You can have it.
Yes.
The file is there only. This is 52, 53.
5960.
No,
So,
this is
okay.
Mr. M. K. Chaudhary was there in the matter,
No, Your
This
Lordship,
is-
in fact, the file has been taken from us.
this matter.
Yes, Your Lord. We are no longer appear in the matter. Your Lordship. Tulika Das and Upen Das.
Hmm?
Tulika Das and Upen Das, those two matters.
Yes, yes.
Yes, the briefs have been taken from our chamber. Your Lordship.
Okay. Both sides are duly represented. Mr. M. Sharma and the counsel, appearing on behalf of Mr. M. K. Chaudhary and senior counsel for the petitioner, submits that the brief has been taken away. And he submits that uh, his chamber is no longer appearing in the matter. Hmm? Okay, for Angel Justice, the matter stands adjourned today. So as as this list is up to 28/4/2023, now this matter will be taken up in the next call. And if the petitioners are still unrepresented, adverse orders may follow. I'm adjourning it today. And Next call. Hmm? Okay.
Obligation.
I apologize for the absence.
That's okay.
My lord,
I told Mr. Fukan, I think you'll have to lodge an FIR and then get it reconstructed, because otherwise we can't perpetuate the delay. So
there was
2000
one other method that I had one more option. Fortunately, one photocopy of the record of the director of director's office is available. Now, from there, we have the issue numbers of the letters. We know the dates. That will also contain the issue numbers of the letters sent to us by the district office. We will know when the duration list was sent, when the select list was sent, what kind of things were done. So, along with, because once we lodge an FIR, what I had thought, there'll be a search in that particular record room of our department. In our, and that would cause quite some problem for us also, because everything will be topsy-turvy by the time they search it out. It has to be done at a time when we have got some time in hand to go through each of the.
No,
files.
police will do that exercise. It has, to my notice, that has been done only once. The police coming and actually searching for it was done only once. I recollect the matter.
In any case, madam, if they give a report that it has been reported.
I'll tell you, I recollect the matter. There was a fight between two coal barons when we were young entrants here. It was a fight between two coal barons. And the wife of one coal baron, there was an allegation that she has eloped with the other. And she lodged an FIR that in Basista police station, she lodged an FIR to the effect that she has lost the keys of her house. Cupboard. So police people promptly came, made a search, And in the search, they found an unlicensed pistol in the house.
Oh,
And then the other, what you call the adversary was sought to be arrested because of that. Now the search was made in the absence of anybody in the house.
so the,
And this pistol was found. So this is the only case I remember where police came and made a search actually for a lost item.
Otherwise, we can have a, they give a GD entry report or something, and then we can.
It's a
get
matter
with
taken
the
up at court
reconstruction.
number, old building, court number 7.
this is also code number 7.
Huh?
This is also code number 7.
What strikes my mind is. They looked for a key and found a gun. It was.
So that's why something I remember. No, but you see, it's your choice, whatever you want to do.
Yes.
But actually, there has to be a reconstruction.
Yes, we can have the reconstruction done once I lodge an entry in with the police that is not traceable. Therefore, we need to reconstruct the file. The original is not traceable. That will be done. And in the meantime, I'll try to have an affidavit.
Because you see, so normally we also tend to make mistakes. So at times the files get misplaced here or there, but this is a matter of 2017. Has to be traced out because this mistake was found out and then they are traced out. Once you have identified that peon book you are having,
Yes.
the receipt is there, the production before the court is there. Normally it is
The only.
otherwise traceable.
Yes.
Because you see, we also keep several records. At times we will not be able to place it when I took it. If you just say that we gave it a week back, I won't remember. But the court master will find out that these are the records which are
Which were
which are interested. Because few days back, case diary was misplaced, but then it was tracked out. It was there. Maybe because of some files, one or two.
At that point of time, they did not keep any soft copy of the files that were being sent to us. And now what they are trying to do is they have made all the official records. They have put it in the computer in PDF format. Neither they send it to us on WhatsApp, or if they send the original, they reconstruct it immediately from the PDF files. That is started from around 2021. When the new commissioner, new secretary took over, she did a lot. Prior to that, it was the original bunch which was sent to us, a peon book signed on my behalf by one of the clerks or anybody, because they were not allowed entry at point of just a signature, and the file was bought and then it was taken back. Then there was a change in the councils. So then entire file had to be shifted
No, that's
from one
okay.
chamber
But,
to another.
but it has to be done.
Somewhere
We
it
can't perpetually wait for the.
Lordship will give me just till the reopening. Whatever documents I have on the photocopy, what I can tally with the issue registers.
And he says that most of the photocopies he has also given in the writ petition.
Writ petition, he has given a few RTI information, at least from the public information officer. I can verify whether these were the copies which were handed over to him, whether such a application was made, and whether these were the copies. And that much I can find. And on the basis of that, since the allegation is basically without publishing the provisional gradation list or the final gradation list, the selection of the headmasters was held and they were given promotions. That is the basic grievance that I have understood. Now, if I can place before this honorable court that there was a provisional gradation list, it was published, objections were not received, final list came, and thereafter we gave the promotions, he would not have a case. But if my records show that the provisional gradation list and the final gradation were not existent or did not tally up, then my lord, the promotions would be in jeopardy. So that is what I was trying to find out, the fact as only to that extent. Whether he had an opportunity
when we can post it again.
My lord, if it is after the beautifications, my lord, perhaps I will be ready with the affidavit before that.
Okay, sir. Mr. S D Purkasthal and counsel for the petitioner, Mr. R Mazumdar, learned standing counsel for the secondary education department,
Element.
elementary education department. Has submitted the person to the audit dated 17/3/2023, comma, and affidavit has been filed by the Director of Elementary Education Assam, regarding the original records which are purportedly sent in connection with another writ petition. As per the registration, is the said affidavit, comma, filed by e-filing on as well as by filing physical copy on 23/3/2023. 23rd you filed. 23, sorry. Next paragraph. The learned standing counsel for the secondary elementary education department has submitted that the authorities have been able to trace out one part of the file in photocopy from where certain particulars are required to be cross-checked. In an attempt to reconstruct the file. In this connection, the learned counsel for the petitioner has also submitted that some of the relevant documents are annexed to his writ petition. Out of his few documents are procured by way of RTI. The learned standing counsel for the secondary education department shall take note of the said submissions. In view of the prayer made, the matter stands adjourned today. List on 26/4/2023. Just add to that, you will not the authorities in the elementary education department shall
It has to be reconstructed. They have to originally go.
take appropriate steps
That is what you are going to do.
as they may be so advised,
Reconstruct.
comma, to reconstruct their lost file in a manner they may be so advised. List on so and so. So I've made an observation that you reconstructed your file. I'm giving you back your affidavit.
May I have the liberty of taking the records so that I can, at least the repetition part, whichever, whatever documents I don't have, I can identify and then I can take. Obliged. Obliged.
So Mr. On the pair made balance, and also for the elementary education department, the court counsel will hand over him the second second copy of the writ petition. Section, okay, whereby the concerned section in charge. AOJ, the oblique AOJ. Civil rule pending section shall hand over the second judge's file to the Lawrence County Council for the elementary education department.
I'm deeply obliged. Obliged.
You have to take it from the section.
Yes. Obliged.
You're also there in the matter.
Yes, Lord.
You're there in the matter for respond number
7 respondents.
for private respondents. Is MDev then consent appeals for the private respondents. Okay.
Sequel is there. Second copy is there. WBC की मान WBC नंबर की मान ये स्टार्ट कर दिया ना पता Madrasa education.
Yes, what is your instructions?
Our instructions are affidavit.
There is no affidavit by you.
There is no affidavit or instruction.
This case is paragraph 9. This is that in computer, he was given 74.99, whereas he was A star and ought to have been given 90%, 91%. And the private respondent, he replies at paragraph 7
Yes.
for para 6 and 7. He's trying to say that everybody got 74.99. Whoever completed written practical work within time were allotted 74.99. He says 91 could not have been. This is a practical.
Those who could take out the printout were given 74.99 and those who could not were given 64.99.
So this 91% marking, how does the petitioner justify?
The petitioner has lesser mark in the HSLC and equal marks in the practical and lesser marks in the Viva VOC, 3 marks less.
Yes.
The prior before that. So HSLC marks of the respondent is more than the petitioner. He scores on that.
Viva will say he scores with 3 more marks.
Hmm.
And at one point, at paragraph 15, the petitioner makes a allegation that there was no written test held. And in reply to that, the respondent says that does not deny it. Sorry, the respondent says the written test was held. So when the written test was held, the procedural infirmity not being there, merely that I should have got this much marks on the basis of my this certificate, would that be enough to invoke the writ jurisdiction?
No, you see, he has a valid ground. If you come to page 26,
26.
that is the notification.
Yes, madam.
Para 7, there's a chart.
Yes, madam.
Now, qualification is HSLC so and so equivalent.
Yes.
Total marks, percentage of marks 65, marks obtained 65.
Means whatever they had obtained.
Yes. Diploma in computer application, written and practical examination. Here it is 60%, it is 60%. So if he is 90 A plus, he said that in between 90 and 100, he gets 91.
No, my lord, if I may just say, these 1-year diploma courses, they are issued by, some are issued by competent authorities which come under the AICTE and all, and some come from simple private institutes which exist in every nook and corner. So they have not given any marks on that. The selection committee has not given any marks on that. Those who could complete the practical examination was given 79, and those who could not were given 69. Separately, marks for that 1-year diploma was not given to anybody. Because someone came from a government institute, some would come from a private institute, some would come from a recognized institute. So therefore, no marks were given on that basis is the standard respondent number 7. So whether they could complete the task or they could not complete the task was the practical examination, which is within the bracket in the same column. One, a written and practical examination. Now, if then it was preference will be given to work experience. One of the grounds taken by the petitioner is that work experience has not been taken into account. But it's settled law by the Supreme Court, preference is given when 2 candidates score equally and one of them needs to be given a preference. Here, he has scored a lesser number by 3 marks, the petitioner. So the preference part will not come in now. Lordship would only like to decide whether not going on the diploma, not giving any marks on diploma and restricting the marks only to written and practical examination when that was one of the conditions in the notification. Would it vitiate the selection process? If not, the wisdom of the selection committee in giving the allotted marks, that cannot be questioned by the petitioner in my humble submission. This diploma, it went up to the Honorable Division Bench also in one of the cases where there were 2 diplomas by 2 different computer centers. One was giving him 98% marks, the other person got 91 marks. 98 could not complete the test, 91 completed the test. Then it went up to the Division Bench saying that my diploma marks should be taken into account. It's pending. There is no stay of the learning signatures, but that is when I was told by the department that usually we do now give marks for the diploma, we give it only on the whatever they could do in the sitting there in the practical examinations is what we take into account. The records from the diploma institutes were also called for. There was some confusion. One time he was given 98%, once he was given 96%. There were 2 certificates, and that sort of a mess was created by the computer institutes. So without going into that, the department, the selection committee in their wisdom has said that whoever completes it gets this much marks.
Okay, let us see. Pick it up at 2 if they come, otherwise. Dismissing all the cases for default is also not the answer.
Those actually interested would come back with a restoration petition. Those actually interested in pursuing come back with a restoration petition. Mostly they remain at first.
Yes, Mr. Sinha, you are there in any matter?
Yes, ma'am. Item number 78, man.
Is the other side there?
Even I can.
78.
At least
Pension matter, my lord. Regarding the pension matter, my lord. Actually, this, my
Pension
lord, Krishna was a teacher, Krishna's father was teacher of Bamanjuri Lower Primary School, my lord.
Just a moment, I don't have the file.
Elementary, secondary, that we have qualified. Even heavy শেষ করবো তো কোন দিকে সব জানি কি ঘাটে সকল ভাইকোটা কোনো Rare goods. Affidavit rare goods. Let's stop affidavit.
But the ground taken is not a good ground to stop payment of his retirement dues.
Since the money was already released to the father of the petitioner during his lifetime for construction, that construction work, and was tackled by him, work remained incomplete. The fund was not there in the school. That has to be recovered from somewhere, my lord.
No, but
Maybe in the DDO, my lord. He has.
no, you see, there has to be a proceedings first. In that proceeding, you will find him guilty,
Yes.
and then you will recover.
From the affidavit, my lord, it also appears that the petitioner said even. Provision 60% and amount of this. Yes. Para 7 of the affidavit, my lord.
Your affidavit.
Our
Ah, yes, I
para
have seen
7,
that.
my lord, that estimated work remain. Then, my lord, para 9. They had assured that they would complete the work. The petitioner and his brother.
It's okay.
At that point of time.
But now in reply, they are saying that this was the coercion because otherwise I would not have received the money.
Yes, because we are the other money that they were entitled to. Plus, you could find a paragraph 10. We had processed everything. We had processed everything, keeping that 446 or 466, 400. barring that 466,400. Now, my lord, if they accepted the other money, the inquiry would have taken some time to find out whether it can be recovered from the account of the father of the petitioner. Without waiting for that, my lord, he is before this honorable court. Once a writ petition is filed, the department seldom proceeds. So, release of this money, my lord, if it is recoverable from the father of the petitioner, that inquiry has to take place and thereafter a decision can be arrived at. The other money we are not disputing. After receiving the succession certificate from the petitioner on 16/9/2015, DIF Schools Morigaon had taken steps to release the provisional death cum retirement gratuity
No,
bill, leave encashment, GIS.
What does the service law applicable say? Can somebody just hold a kangaroo court and arrive at a decision that?
That entire inquiry has to be done by auditing and who released the money, whether it was released to the contractor before completion of the bills, whatever. That part inquiry has to be done. Before we could complete the inquiry, we have to keep that money on hold. Whatever amount is according to us recoverable has to be kept on hold. It was kept on hold, the rest was offered to them.
No, but
They
you
have
see-
not received the entire amount.
You see, the writ petition was filed in 2017.
17.
If you don't proceed, we can't
Well,
stop it.
once it comes within the ambit of this honorable court, my lord, the petition is filed. That other portion is kept on hold by the department, my lord.
But then they suffer for it.
My lord.
They will suffer for it. Nobody state this, any inquiry.
No inquiry, my lord.
No, inquiry has not been seen.
Inquiry was never,
My
this
lord,
court did
in
not
my
stop
humble
it.
submission, because, my lord, they should not lose out money that belongs to them, and the government should also, on the other hand, not suffer. If lordship fixes a particular time frame, let it be a month, let it be 2 months. If within that time frame we can show, or we have any inquiry report to show that this money is recoverable.
No, you see, not in his writ petition. Because there's nobody is debarring you from proceeding.
If the money is likely to be released, my lord, this part of the money is likely to be released, it will never be recoverable from them. It has to be kept with the department or they take it under with an undertaking that they will refund it if our inquiry shows that this money is due to the government. We are not holding back the entire money. The money that has been found to be the work part that has been remaining. 9 lakhs was released and work amounting to rupees 4,46,400 was still to be done.
No, you see, what I've understood is that he was paid the
I'm
gratuity.
sorry, my lord, they have taken that money also.
They have taken that money.
Yes,
Now,
Question is
there was
not
there was an order issued by you for refund of that money.
yes. They don't want to refund it.
Yes, and then therefore not to refer the opposite court, and this court by an interim order of 28/4/2017
Yes.
in an interim directed that the petitioner may not refund the money.
Order to pretty money more previous to Till further orders, petitioner may not refund the amount of rupees 4,60,000.
So for refund also, because now it's not that what you are saying.
Yes,
Once it is a
I
refund,
had a wrong question, I'm sorry. madam.
once it is a question of refund, you'll have to arrive at a finding that yes,
Finding,
this
and
is.
thereafter with the. You must have been disposed of on that line that without coming to a proper finding based on a proper inquiry.
But it's in the section
Clarifying
after
the
4 years,
process.
my lord, there can be inquiry, my lord. After section 21, my lord, our high court judgment is also there, my lord.
No, this is not a
After
misconduct.
4 years, my lord.
This is not about a
Make an
misconduct.
inquiry whatsoever, my lord.
Person
There
died
may
in-
either judicial or
No, if
admission.
they do, they'll have to challenge it again. But for the time
But
being, they are
judgment is
closing
there,
it.
my lord. Honorable Supreme Court judgment is there, my lord. And our high court judgment is also there, my lord. I'm plain.
person died in 2015, he was before this honorable court in 2017, 2 years. From that time on, no refund was required. Department did not initiate any other proceeding. Now that the matter will be closed, we have another 2 years because 4 years is the time limit.
No,
Time spent in
that-
judicial
no, no.
proceeding has to be, my lord.
For that you don't get extension or limitation.
My lord.
For that you don't get extension or limitation because the court did not stay the inquiry. What was the directed was only not to insist on the refund.
Whether it was completed. The inquiry, my lord, apparently is complete because we have also found to an estimate of rupees. That 4,63,400, an amount has been arrived at. There must have been an inquiry.
Our High Court recent judgment also there, my lord. Our High Court recent judgment is also there in this time.
Five to 23. On 5 to 2013, he died. 4/5/13, we have that. Open social media and site inspection report, please. Their name to be. You know, their name to.
Good. So, maybe another and counsel for the petitioner. It is Mr. R. Mazumdar. Standing also for the. This is elementary education or secondary? Secondary education department appearing for respondent numbers 1, 3, 4 and 1, 3, 4, 5 and 6. And Mr. Shalia and standing also for finance department appearing for respondent number 2. Who's for directorate of pension?
Government advocate appears.
Government advocate? It's okay, she was there, what do you call? It's okay, who was here? Bokolier was here. I record his name, Mr. Bokolier. So G. Bokolier and I comment advocate appearing for respondent number 7. I, the director of pension. Next paragraph. The petitioner is the father of the petitioner, namely late Balaram Sarkar. At the relevant point of time was the headmaster of which school?
Bamunjuri Lower Primary School.
Baman
Judy.
Bamunjari BAMUNJARI LP school First of while in service, he died in harness on 5/2/2013. While serving the said post. While performing his duty as a polling officer during the Assam Panchayat election, 2013. Full stop. Thereafter, the petitioner applied for payment of death cum retirement gratuity, leave encashment benefit, group insurance scheme, and other receivables. Full stop. The Deputy Inspector of Schools, Morigaon, respondent number 5. Issued an order dated 2/6/2015, thereby directing the petitioner to refund a sum of rupees 4,66,400 out of the gratuity, earned leave, encashment, benefit, GIS, etc. On the ground that the father of the petitioner, namely late Balaram Sarkar, was responsible for the construction of new school building of the Bamunjari Namapara NAMA PARA primary school, and that the construction work quantified at rupees 4,66,400 remained pending during his lifetime. Next, for the Honorable Counsel for the petitioner has submitted that the order passed for recovery of the amount was in violation of Rule 21 of the Assam Services within bracket pension bracket was rules, 1969. So accordingly, by filing this writ petition in Article 226 of the Constitution of India, the petitioner has sent the impugn order dated 2/6/2015. Next paragraph. The Learned Stand Coast for the Secondary Education Department has submitted that as the authorities have quantified the refund amount of rupees 4,66,400, there is every likelihood that a departmental proceeding or any other inquiry had been held against the father of the petitioner. First of all, referring to the statements made in the affidavit in opposition filed by the respondent number, by the Director of Elementary Education within bracket respondent number 3. Comment is submitted that at the time of death of the father of the petitioner, the work in progress was only to the extent of 60% as on 4/5/2013, but an amount of rupees 9.9 lakh was released before the estimated cost of the balance work was calculated at rupees 4,66,400. And that the construction was as the father of the petitioner was responsible for the correction for the construction, or the amount became recoverable from him. So it is also submitted that the Deputy Inspector of Schools, Morigaon, had taken steps to release the provisional death cum retirement gratuity, leave and encashment benefit, GIS, etc. But the petitioner refused to receive the amount because of deduction of a sum of rupees 4,66,400. Next para. From the materials available on record, it does not appear that any departmental proceedings was taken up against the father of the petitioner. Nor there are any other materials to show that the father of the petitioner had misappropriated the amount. So therefore, in the absence of any material to show that any proceedings was drawn up and the same was a basis for seeking refund of rupees 4,66,400. On the court is of the considered opinion that the order of refund, the impugn order 26/2015 requiring the petitioner to refund the amount is not sustainable. Next, learned study council for the Elementary Education Department. The Secondary Education Department has submitted that as the amount has been quantified, but there is every likelihood that a proceedings has been drawn up against the father of the petitioner. And it is submitted that as the petitioner has undertaken complete the construction It is also possible that owing to such admission, formal proceedings was not drawn up. So, in this regard, the court is of the considered opinion that if there has already been a proceedings drawn up against the father of the petitioner within the time prescribed under the Assam Services within bracket pension bracket close rules, 1969, it could have been permissible to recover the amount from the retirement benefits of the father of the petitioner. First off, in the absence of any disciplinary and or criminal proceedings, now the court is of the considered opinion that the withholding of the disbursement of benefits like benefits of gratuity, earned leave, GIS, etc. Pending adjustment against incomplete construction works for the extent of rupees to the extent of rupees 4,66,400. Is not sustainable. Expert the non-concept of the petitioner has referred to the case of state of Jharkhand and others versus Jitendra Kumar Srivastav and another 2013 12 SCC 210. The project that in the absence of invoking any particular rule permitting adjustment of the recovery amount from if any from the gratuity, earned leave and GIS money was not sustainable. Stop. in view of above. You know the ratio laid out in the case of Jitendra Kumar Srivastava within bracket Supra. And further considering that no document has been produced by the respondent authorities to show that by virtue of any proceedings, the liability in respect of alleged liability in relation to unfinished incomplete construction work would be adjusted against dues under gratuity, leave, earned leave and CIS money, GIS money. And the court is inclined to hold that the impugned order under number page 17, number so and so dated 2/6/2010. 2015. 2015 is not sustainable and the same is set as and flashed. So the responding authorities, however, would be you just say that this amount would not come in the way, this order would not come in the way for the respondent authorities if they have already initiated any lawful proceedings and same is brought to its logical end. Okay. The next paragraph, accordingly, the unpaid amount, if any, to the petitioner shall be disbursed within an outer period of 3 months
3 months or 2 months.
from the date of from the date when the certified copy of this order is served on whom? Inspector of schools. Concerned inspector of schools. Which place?
Morigaon.
Morigaon.
Well, it will be the elementary education department. I apologize.
Elementary education.
secondary
No,
will
secondary, elementary.
Order passed by Deputy University School.
The elementary assessor.
Okay.
I'm led by Mr. R.P. Kapi. Lordship, he is out of station.
Okay.
Matter will be taken
Next week then.
of last question.
All sides are duly represented on the prayer made by Mr. B. Sutradhar and counsel for the petitioner in WBC.
In item 60. In petition number, Lordship in WBC 158 2017.
So 158 of 2017. Matter stands adjourned today. It will be taken up in the next call on the next week. Rest of the items, in view of order passed in view of the order passed in connected WBC 158 of 2017. Matter will be taken up in the next call.
Item number 82, it may not be taken today. We need the.
82, I don't think I'll reach by then. Let us see the previous items. Uh, None appears to call for the petitioner. Mr. R. Mazumdar and his standing counsel for the secondary education department is present. As per the learned standing counsel for the secondary education department has submitted that in this particular case, the appointment was for the post, the appointment was for the post of junior assistant of Howrah Par, HOWRAR PAR, senior madrasa. And that as the candidates had produced computer certificates from the government as well as private institutions, and there was no standardization of the training, or the respondent authorities, sorry, the school, the selection committee had granted marks to the candidates on the basis of their ability to complete the task. And therefore he submits that there was a rational basis to award marks to the candidates. Be that as it may, the petitioner was absent when the matter was previously listed on 23/3/2023, and in the second call made today, the petitioner is again absent on call. So accordingly, it appears that the petitioner is not interested to pursue this matter. Accordingly, this matter stands dismissed for non-prosecution.
and 16.
Yes.
Your Lordship, item number 59 is WPC 2561/2016,
Yes.
which is a fallout of the writ petition at item number 60, which is 4770/2015.
Yes.
Your Lordship, if your Lordship permits me, can I, if I may have access to the file, Your Lordship, before the second?
Yes.
Yes, please.
We'll take it up after some time.
No, I have gone through the matter, Your Lordship. I do the matter if your Lordship permits. Yes. Your Lordship will kindly come to page 28, Your Lordship. page 28
of
of
4770,
no, your lordship, 2561 of 2016.
2561,
Yes, your lord.
page
Page 28,
28.
page 28. Ah.
Yes,
Yes,
Right, period, Lordship, I am
Lordship,
interrupting, Lordship. Here, Lordship, earlier of them, Tesco University is separate set of council, Lordship. I to handed over to the central government, Lordship. So, Lordship, if fix any other day, I inform that DSGI, Lordship, whether it was allotted or not, Lordship. Otherwise, Lordship,
oh, achha.
Lordship, that is the reason, Lordship.
in fact, my senior Mr. NC Das sir was.
Earlier, because Dastar is appeared, now they have, Lordship, handed over all the bid to the central government, Lordship. So,
Okay.
Lordship, whether it was allotted or not, Lordship, I will inform the DSGI, Lordship.
Mr. M. Sharma, the counsel for the petitioner, is present. Mr. K. Goel at CGC, who also gives when CGC submits that earlier Tezpur University was being represented by private, represented by their own counsel. But in recent times, the central government council, the ASGI of the central the CGCs are interested in the matters. We prays for some time to obtain appropriate instructions.
Lordship, Lordship.
So accordingly, medicines adjourned today, as this list is up to 28/4/2023. The matter will be taken up in the next call. Okay. I'll just say next call.
Lordship, Lordship, Lordship. Lordship.
Sixty-one.
You have instructions when this college was brought in the category of grant in aid, deficit grant in aid system.
Lordship.
He's claiming, you 1 second, right?
Lordship, Lordship. Lordship.
In this case, he is claiming that his gross qualifying salary, service
Lordship.
was considered to be 14 years, 3 months. It should have been 31 years.
Lordship, earlier college was not counted. He is probably there is there, Lordship. The college he has earlier he has rendered his service is not counted. That
Yes,
Lordship.
because the stand of the AG
Lordship.
is that during that time,
Lordship.
the college was under, this college was a venture college.
Cancer college and he is
Therefore,
in ad hoc service in the Ropohi college, Lordship.
ah,
That's why that period was not counted, Lordship.
yes,
Lordship, that is the reason, Lordship. And Lordship, the period which he has spent in the MC college, Borpeta is treated as a qualifying service period, Lordship. because it is in Granson 8 also provincial service also lordship. And the Rupohi College service part is not considered because the ad hoc appointment was there lordship. In the Bhansar state lordship.
You see, see this.
Lordship,
See, under 121,
lordship.
if he has done service in two colleges, the combination of service
Lordship.
under 121 is past service
Past
could have
service
been taken. And this Rupohi College,
lordship,
it was provincialized
lordship,
on 11/1/1996.
lordship. And before that lordship, he was in lordship, MC College lordship.
Yes,
Lordship in a ad hoc basis, not against the lordship. Any
but
permanent.
Rupohi College, I couldn't find out where is that Rupohi College. Just check out.
He retired from Rupohi College as principal lordship, and that period was counted lordship. Lordship and principal.
You see, he joined there, page 23. Please
Lordship,
see page 23.
lordship, lordship.
The offer letter is 16/8/88. So this college was brought under Granson 8 from 11/1/1996.
Lordship.
Oh, acha, from that day he got the benefit.
Lordship,
Okay,
lordship,
okay,
lordship.
okay. I get it.
He is seeking benefit lordship, that earlier period should be counted lordship. That is not counted, and that parties cannot be considered as a lordship qualifying service period lordship. Also, in our affidavit, paragraph 6, Lordship, we have stated, Lordship, paragraph 6, Lordship.
Mr. Goway,
Lordship,
please take the affidavit in opposition.
Lordship,
Sorry, the affidavit in reply
Lordship, Lordship,
filed by the petitioner
Lordship,
on 27/11/2017.
Lordship,
27/11/2017.
Lordship,
You got it?
Lordship.
Now, in this, you'll find a letter at page 7.
Page 7, Lordship. Plus, it
Correct.
is senior accounts officer, Lordship,
Huh.
Lordship,
Now, this says
Lordship,
that in the form 2,
Lordship,
it was specifically mentioned that it is not to be treated as qualifying service.
Lordship, Lordship,
Correct, and therefore they say it can't be done.
Lordship, Lordship.
Now, at the page 14 and 15.
Lordship,
15 is your letter. Please see page 14 first and then come to 15.
Lordship, Lordship. 14, Lordship,
Yes.
14. Lordship,
Yes, after that, page 15.
Lordship, 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 I have seen.
So therefore,
Lordship.
you had considered his case of withdrawal of that condition.
Lordship's that no final decision was taken, Lordship. Just it is indicated that, Lordship, with reference to the subjects, I am directed to request you to furnish the order copy of withdrawal of the condition imposed in the approval of the appointment. To this directed as early as possible of taking further course Ex post facto approval for allowing the lecturer concerned in joining new assignment the principal with counting the past service. Just the indication lordship, no final decision was taken lordship.
No, that was taken,
Lordship.
page 17.
Page 17 is the earlier order lordship, earlier order where he was appointed as the MC college lordship,
Acha.
MC college Borpeta lordship.
Okay.
And lordship, he left that particular job in own interest. Then lordship, he that sanction post was he left lordship, and after that he joined that particular Vensa stage of college lordship. In Vensa stage, he has joined in Rupohi college lordship. He left the job in MC college and joined Rupohi college lordship in the Vensa stage lordship. So the accountant general's only that ground accountant general finding is there lordship in page 7 lordship. Page 7 of the affidavit in reply lordship.
Yes.
Lordship.
So higher education department did not give the approval
Lordship.
for withdrawal of the condition.
Lordship. And he also left his own volume, lordship. He, in own interest, he has joined as lordship Venture college lordship.
MC college was a provisionalized college.
MC college, Gramsci Net college.
Gramsci
At
Net
that
College.
relevant point of time, lordship, Gramsci Net college, and that college was under the provincialization under the 2005 Act, lordship. Before it's come under the provincialization, lordship, he has left the college, lordship. Earlier, okay, it's a Gramsci Net college, lordship, up to 2005 MC.
So therefore, there would be a break according to you.
Lordship.
The period when his service is in Grantinate College.
Lordship, Grantinate college, lordship, before it will come to purview under the provincialization act, lordship, before that he has left the college, lordship.
And that's what.
Lordship.
So therefore, that it would not be a continuous service so far
Lordship.
as government is concerned.
Lordship.
None appears on call for the petitioner. Mr. K. Govind, on standing counsel for the higher education department, is present. And he is referred to the affidavit in opposition filed by the respondent number 3, as well as affidavit in make it serially, respondent number 2 and respondent number 3. I have submitted that there's no document on record to show that the petitioner had become lawfully entitled to have his net, to have his gross service and net qualifying service increased from 14 years, 3 months and 21 days with effect from 11/1/1996 to 34/2010 TO2, 31 years, 8 months and 15 days with effect from 16/8/1978, TO2, 30/4/2010. And in the said context, it is submitted that the petitioner was earlier in service in MC College, Borbetta. Left the said college on 1/9/1988 in his own interest and joined as principal in charge of Rupohi College, Nagaon from 2/9/1988, which was a venture college. And that the said college was brought under the deficit system of granting aid only on 11/1/1996. Next, be the resignation. It is noted that the petitioner was absent on call when the matter was previously listed on 23/3/2023. Again, when the matter is taken up on the second call, the petitioner is found unrepresented. As this, the court is of the consideration opinion that the petitioner is not inclined to pursue the matter, and therefore this stands dismissed for non-prosecution.
Well,
Within this item 70, anybody, both sides are ready in any matter?
Item number 63, I am there, but today I have not got the brief. That is
Okay. Okay. Taken up in the next call then? On the prayer made by Mr. S.D. Prakasan and counsel for the petitioner, item 63. Matter will be taken up in the next call. Item 62. Nobody? No? Okay. Then Mr. Gogoi, I realize unnecessary because instead of dismissing all the matters. Yes.
But I have a matter in 87. Well, not so good, but can it be possible to take up today?
80.
87.
Is the other side ready? There are several counsel for the respondents, private respondents. Are they here? No. In the absence, I may not like to take it up. For the next date, if they are there, we will take it up the matter. I'm fixing dress matters in this too.
regarding lordship,
No, not that. Tuesdays and Thursdays, so that I can touch up
lordship.
part two matters, and now these part two matters are being adjourned.
Lordship.